Mr. Chief Justice, and may it please this honorable court, my name is Marcia Mignot, and I have the honor of representing the appellant. Brief facts of the case is that the appellant was riding his motorcycle, was hit by a car. Officers arrived to the scene, suspected that he was under the influence. The officers requested a roadside portable breath test, and the appellant refused. Appellant's refusal was used as evidence at trial to convict. Our fundamental position in this case is that Georgia Constitution 1983, Article 1, Section 1, Paragraph 16 states in pertinent part, no person shall be compelled to give testimony tending in any manner to be self-incriminating. Paragraph 16 are constitutional rights that apply pre and post arrest. Roadside portable breath test requires a citizen to act. And this honorable court held in Olivet that breathing deep lung air into a breathalyzer is a self-incriminating act that paragraph 16 prevents the state from compelling. As seen on the demonstrative video provided to this honorable court, the suspect has to 1, act by taking a deep breath, and 2, by blowing until the officer commands him or her to stop. Definition of an act was also affirmed by this honorable court in Elliott, and Elliott prevents the state from presenting appellant's refusal as evidence, because this court held in Elliott, because Elliott had the right to refuse to submit to a breath test under paragraph 16, admission of evidence of her refusal violates the state constitutional right against compelled self-incrimination. This court must then overturn the ruling in Keenan because Keenan was based on bad law. Keenan was founded upon OCGA 24-9-20, which has since been repealed. Keenan was also decided based on Allen v. State 254, Georgia 433, 1985, which was overturned by Olivet October 16, 2017. And Keenan was also founded upon OCGA 40-6-392, which was repealed. Additionally, the appellant in the Keenan matter argued his refusal to undergo the Alco-Sensor portable breath test was inadmissible under the Fifth Amendment of the United States Constitution. This argument was incorrect because appellant should have argued that it is inadmissible pursuant to paragraph 16 of the Georgia Constitution. Most notably is that the court in Keenan failed to address paragraph 16. At this time, I welcome questions from the justices and would reserve any additional time for rebuttal.
Can you explain, just clarify, was this issue preserved from the start in the motion to suppress?
Yes, Justice Niemes, it was.
So the motion to suppress specifically sought, or at trial, there was a specific objection to the refusal, the use of refusal evidence for the ALCA sensor test.
Yes, Justice Niemes.
Okay, and can you also explain that the Court of Appeals seems to have held that the evidence was harmless in any event? Why would that be incorrect? Assuming we agreed with you that the evidence should have been excluded of the Alka-Seltz sensor, there seems to have been quite a bit of other evidence that your client was driving less safe.
The issue, Justice Niemes, is that paragraph 16 provides a constitutional right of the appellant not to act, and him invoking his paragraph 16 rights was violated by the fact that the jurors were advised that he refused.
Counsel, let me ask that question another way. So you would agree that the evidence in this case was that the appellant clipped the side view mirror of another car and then was subsequently involved in an accident, correct?
Well, Justice Boggs, the facts are that when the officers arrived, they could not determine who caused the accident. And my client's position, the appellant's position, was that the driver of the automobile caused the accident.
He caused the accident. I said he was involved in an accident. You would agree he was involved in an accident?
I do agree, Justice Boggs.
You agree that there's evidence from which a jury could conclude that prior to that accident, he clipped the side view mirror of a car?
I would agree to that, Justice Boggs, but that still does not remove the issue that we have of his constitutional rights being violated.
Let me get to the end of my question. So I'm trying to stack up the evidence here and get to Justice Namias's question about prejudice. So in addition, while he admitted originally that he had nothing to drink, you would agree that an officer testified that subsequently he at least admitted to that officer that he had one beer, correct?
That is correct, Justice Boggs.
In addition, his eyes, at least according to the officer, were red and glassy. The officers detected alcohol on his breath, according to their testimony, correct?
According to their testimony, Justice Boggs, that is in the record.
So absent this testimony that you think was objectionable and violative of the Constitution, was there sufficient evidence for the jury to convict this driver of being less safe?
Not in our position. And that's because there was also evidence that the appellant had bloodshot eyes because of eye surgery. And those issues were raised to law enforcement at the roadside.
Well, there plainly was sufficient evidence to convict him. I think what your argument is that while there may have been sufficient evidence, because the jury didn't have to believe what was said about the bloodshot eyes. I think what your argument is that while it was sufficient, it wasn't harmless. It wasn't so overwhelming evidence that the admission of the refusal was harmless. Is that your argument?
Justice Peterson, that is correct.
So why wasn't it harmless? Because it does sound like there was rather a lot that the jury heard in addition to the refusal evidence.
And to answer your question, Justice Peterson, it's because the paragraph 16 constitutional rights are such heavily protected rights.
That's talking about why the constitutional issue is important. That's not responsive to the question of what was the actual factual impact of the refusal in the context of all the other evidence that was in.
Well, that is because the jurors are drawing the inference from the testimony that is sufficient evidence that the appellant would have been guilty of driving under the influence.
That's just one inference. Didn't your client also refuse a state-administered blood test?
That is correct, Justice Nemes.
Okay, and we have not granted cert on that because that refusal properly came into evidence. Given the refusal after arrest and implied consent warnings, the refusal to agree to a blood test that is not challenged here today, why would the refusal to take an Alka-Seltzer test, which just tells you whether or not there is any alcohol in your blood, why would the jury have considered that more than a refusal of a test that tells you precisely how much alcohol is in your blood?
Because if you look at the demonstrative that is provided, the officer is actually getting a number, Justice Nemes, and although that number is not presented to the jury, other than in officer testimony of positive or negative, it's still evidence that's used and presented to the jury.
I got that. So the jury knew that he had declined a test that all they would have been told about is he had alcohol in his system or not. There's evidence that officers smelled alcohol on him, and he acknowledged, ultimately, after lying, the jury could find, he acknowledged that he had drunk alcohol. He also then refused a test that actually determines how much alcohol is in your system. Why is this singular, refusal to take just the Alka-Seltzer test? It's hard to understand why that would have made a difference.
Well, Justice Nemes, it would have made a difference because now the jurors would not have a stacking of the evidence in terms of the testimony of the officer and also whether it's a positive or a negative that they're presenting to the office, to the jury. The jury would not.
Is that how we look at the harmless? I mean, I understand the stacking argument you make, an argument that I would think would be analogous to the cumulative nature of the evidence. But to Justice Namias's question, if the refusal to submit to the Alka-Seltzer test was admitted improperly, if the jury considered that then obviously, and it contributed to their verdict, obviously it goes to the question in the analysis of harmlessness. But taking that away, there was still the properly admitted refusal to submit to a blood test and all of the other evidence that I just suggested from which the jury could reasonably infer, could they not, that he was a less safe driver, including his admission that he had one beer. So I'm still struggling with your argument about why this particular evidence, constitutionally violative as it might be, is going to make this case that going to contribute to a verdict in such a way that this was not a harmless error.
Well, there were lots of errors, Justice, that were raised. However, the court has asked us to just address the issue regarding the portable breath test.
Well, and to that point, I thought I heard you earlier to Justice Namias's question state relative to whether this issue was preserved for appeal, that there was an affirmative objection to the admission of that refusal at trial when the officer testified. But the state says that's not the case. And I've reviewed the transcript, and I've reviewed particularly transcript pages 135 and 136, where the officer testified, police sergeant actually testified, that Adams refused the Alka-Seltzer test and that there was no objection. So can you point me to the record as to where the objection was?
And Justice Boggs, that means I apologize to the court. I was not trial counsel. I am appellate counsel as it pertains to the transcript. I may have misspoken. It was my understanding based on my review of the voluminous records, because this was a 3-day trial.
I get that. We often get appellate counsel that didn't try cases, but nonetheless, as appellate counsel, you've got to demonstrate that the error was preserved. And so my question to you is if you assume for argument's sake that when the sergeant testified as to the refusal and there was no objection, can you illuminate for us how this issue that you're arguing was properly preserved for appellate review?
Well, a motion for new trial was filed with the court timely, and the issue was also raised at the motion for new trial with the trial court regarding it being violative of the appellant's constitutional rights. And that motion for new trial was denied by the trial court, and the issue of Elliott was also addressed.
That's too late to raise a constitutional argument, except under plain error review.
And Your Honor, we do submit to this honorable court that the trial court, sua sponte, had the right to stop an error when it occurs at trial.
But that's plain error review. So that increases your harm showing even more. It puts the burden on you to show harm rather than the state to show harm no harm beyond a reasonable doubt.
It also requires you to show that any error was clear, which is hard to do when the whole issue in the case is, should we overrule precedent that supported admission?
And the issue is this court has addressed the breathalyzer test in the case of Elliott. And the breakdown of this court's analysis in the case of Elliott does not differentiate. The appellant has to do the exact same acts as with the portable breath test as they have to do with the intoxilizer.
You're not wrong about that, but Keenan is still precedent. We have not overruled it, and the Court of Appeals is right to follow Keenan until we tell them to stop.
And hence we're here today, Justice Peterson, to ask
more specifically to that point. Wouldn't the trial court be right to follow Keenan? I mean, you're saying I think we've established that you're in plain error review, and to Justice Peterson's point, you've got to show a clear. And if the trial court is sitting there looking at Keenan, how could they know that Keenan shouldn't be followed?
Because Elliott, Justice Peterson has been, or Justice Bethel, I apologize. Elliott has given the trial court the direction as it pertains to the argument made by the appellant.
Had we overruled Keenan at that point?
Keenan had not been overruled, but Elliott had been in place at that point.
But what are trial courts supposed to do with cases when they have not been overruled yet? Even if they see something coming down the pike or think they do, what is their job?
Well, we understand, Justice Warren, that the trial court has to follow the law that has not been overturned. hence why the appellant is here today asking this court to fix the issue that is going to.
Counsel, that begs the question as to preservation. I mean, in fact, the trial court was obligated, was the trial court not, to follow Keenan until you raise a constitutional question and give the court the opportunity to weigh in on the propriety of the Constitution as applied to these facts, which then preserves that question for our review. And that's kind of the problem here, is that the trial court had to rely on Keenan if they're faithful to their obligation.
But at the time, Justice Boggs, that the trial court was relying on Keenan, the Elliott case, Keenan had also been, the case law that had supported Keenan had been overturned. The statutes had been reversed.
So much of that is true, but Keenan expressly has not been overruled. I mean, I think your substantive arguments on whether Keenan should be overruled in a case where the question is preserved are very strong. But until such time as Keenan is overruled, it remains binding on the Court of Appeals and trial courts.
I mean, your argument would be a lot different if Keenan had been overruled in Elliott, right?
That is correct, Justice Boggs. Hence,
or if you weren't on plain error, if you'd preserved it, then we really could get to the question of whether you overrule Keenan. But it is not plain error for the trial court to follow what was binding case law at that time.
I agree, Justice Peterson, but if you look at the record, you'll see that the ineffective assistance of counsel was one of the grounds by which.
But it's also not ineffective to ask, to fail to argue that existing case law should be overruled.
And that issue isn't before us on cert.
I understand, Justice Boggs, but the court is asking questions that would not allow me to, in a vacuum, leave those issues unaddressed. And we did argue the ineffective assistance of counsel because counsel should have made the argument that it was unconstitutional at trial for the testimony or the refusal to have been presented to the jury as evidence.
Maybe that's the case, and I might very well agree with you. But then we would also, on an ineffective assistance of counsel claim, be still looking at this question of prejudice as to the ultimate verdict and the contribution that this particular evidence would have had toward the entirety of all the evidence that the jury heard and what inferences they could draw from that. Correct?
That is correct, Justice Boggs. But there is also evidence that the appellant had eye surgery and had issues with his eyes, and the state focused solely on his eyes in their closing argument, instructing the jurors to look at the glassy eyes and listen to the testimony of the officers to use it to convict. So ineffective assistance of counsel was broad.
Juries get to decide what weight they apply to the witnesses, correct? I mean,
that is correct.
Just believe everything your client said, right?
That is correct, Justice Boggs. However, their jury charges are also instructing the jurors to use and draw inference from the evidence, which is testimonial evidence from an officer, which states that he refused. And, we think his refusal is a consciousness of guilt, especially if you look at even the state's position or the amicus's position on behalf of the state.
Was that charge with respect to the inferences that could be drawn from the refusal specific as to the Alka-Seltzer test or also as to the blood test?
I believe it might have been regarding both because the jury charge is not clear. It does not differentiate between blood or the Alka-Seltzer breath test.
Thank you.
Thank you, Justice. I'd like to reserve my additional time if there are no other questions for rebuttal.
Yeah. Okay. Yes, ma'am. Ms. Lewis.
Thank you, Mr. Chief Justice, and may it please the court. My name is Audrey Lewis, and I represent the state of Georgia, the appellee in the matter before the court today. This court has granted petition for certiorari on the issue of Keenan. However, before I get into my argument with respect to Keenan, I would like to take this opportunity to clarify and address some of Your Honor's questions with respect to appellant's counsel. First, Justice Boggs, you correctly noted that this issue was not preserved at the trial level, either through a motion to suppress nor an objection at trial. Furthermore, this issue was not raised at the motion for new trial either. If the court looks at the record with respect to the motion for new trial heard on March 26th of 2019, the bulk of the record it is actually a disagreement between the view of which test was actually administered. And it was appellant's position that pursuant to implied consent, both a blood and breath test was issued. And the trial counsel for the state attempted to clarify that the breath test at issue was an Alka-Sensor test and that the state administered test was indeed a blood test. And the trial court asked appellant counsel to clarify, or did the appellant counsel agree? And appellant's counsel disagreed with that position. So the issue was not raised at the motion for new trial level. And quite honestly, it was not even really firmly addressed in the Court of Appeals. The Court of Appeals issued its opinion and cited Keenan versus the state, which marks the issue for today.
Ms. Lewis, thank you for clearing that up. Can you speak to the harmless plain error sort of analysis next? And I don't know if I captured all of the pertinent evidence relative to what weight the jury could have given to his glassy eyes and his admission to drinking and his involvement in a wreck. But can you go through that sort of analysis for us, please?
Absolutely, Your Honor. I think that the court covered it quite nicely, actually. And actually, the Honorable Shalonda Jones Parker issued a very extensive order with respect to the motion for new trial. And indeed, there was a lot of discussion about that in the record. And at the motion for new trial, she ascertained that a lot of the weight, at least in evaluating it as the 13th juror, so to speak, was that the decision to testify probably weighed heavily in the decision. She also cited to and pointed to much of the evidence that Your Honor did, that there was testimony from 2 officers, that there were some manifestations of possible impairment, the smell of alcohol being paramount. Also, as Your Honors pointed out, the refusal with respect to the blood test pursuant to implied consent, and then the administration of the horizontal gaze nystagmus test. And I believe the testimony showed there that there were 6 out of 6 clues, and that factored into the impairment analysis. And so the jury would be able to take that information and, again, as Justice Boggs aptly pointed out, give it what weight it may. And of course, they decided to convict Mr. Adams in light of all that evidence that the state introduced. And so we would agree with the court that.
Thank you, Ms. Lewis. Could we maybe, let's, for argument's sake, we get past all of that and we move to the merits?
Yes, Your Honor.
We got good briefing from amicus in this case, Defense Lawyers Association in particular. Can you talk quite a bit about the merits of the case here?
Absolutely. Your Honor, the question before the court today is whether or not this court should retain Keenan versus the state, located at 263 Georgia 569, in light of its Elliott case. In the Keenan case, I'd like to just also, in addressing that, clarify a point made by appellant counsel with respect to the holding of Keenan. Keenan does reference Allen, and of course, we would concede that there may be parts of Keenan that are certainly not in line with the current state of law. But Keenan actually, with respect to 46-392, found that Alka-Sensor tests don't apply. And so the fact that it was later invalidated in Elliott versus the state doesn't bear on that issue in the context of Alka-Sensor tests.
It doesn't, but we also have made clear, as said in Keenan, that statute only applies after formal charges. So that really has nothing to do with a paragraph 16 constitutional argument, right?
Correct, Your Honor. Paragraph 16.
That's a statutory holding.
Yes, Your Honor. And that's what I was attempting to clarify, Justice Namias. Thank you. That the statutory preclusions of the former in self-incrimination statute are distinct from the Georgia Constitution. However, in its holding, it does conclude, after doing an analysis pursuant to the Fifth and the statute, that there's no violation either with respect to the Georgia Constitution.
Okay, so Keenan based a Georgia constitutional holding on the absence of a federal constitutional violation and the absence of a Georgia statutory violation. Hence, the Georgia Constitution does not get violated. That's what they did. Is that at all the way you would actually figure out if paragraph 16 was violated?
No, Your Honor, I don't believe so. And Justice Namias, you are correct in pointing out some of the confusion there with the Keenan holding. I think part of that is because they made an attempt to analogize it under so many different facets of the right against self-incrimination. However, we do believe that this court could take a principled stance with respect to its cite to Turrentine versus the state, a 1985 Court of Appeals case in which, and I'm sorry, my memory fails me, which Justice pointed out, I believe it might have been you, Justice Namias, that these tests are different than the breathalyzer test, that these tests are only initial screening tests and that the result—
Do they require the cooperation of the defendant?
I think that is a point of debate, Justice Peterson. I think that, unfortunately, with respect to this case, because it wasn't raised at the motion.
So an officer can actually perform an Alka-Seltzer test without any cooperation at all from a defendant on the side of the road?
I think that there would be some. I think that would go to the issue of whether this is an affirmative act analogous to the breathalyzer test. The record here, however, in this case, was not really developed as to that issue because the motion for neutral—
I mean, part of this is we're talking in artificialities because it wasn't preserved, but there are plenty of Court of Appeals cases. I mean, is the state really saying, I know what it may not be in the record, but there are Court of Appeals cases that describe the Alka-Seltzer test in terms almost identical to the intoxilizer, as do all of the literature on it. So, I mean, in the normal Alka-Seltzer case, is the defendant required to do things that the defendant would not normally have to do?
I think, Justice Namias, I am aware that there are some passive capture tests, and I won't hold myself out to be an expert with respect to those. And I certainly wouldn't mislead the court into saying that may have or may not have been the type of test utilized here. I think, Presiding Justice Namias, if I understand you, you're nodding to the Court of Appeals decision that came after the Court of Appeals sided with us in this case, Bradbury versus the state. And I think that case, although was correct in recognizing Elliott in an attempt to reconcile Elliott in the context of portable breath tests, but I think, as was previously pointed out by your honors, that one of the things that Bradbury fails to do is even consider Keenan in light of the Elliott decision. And at that time, Keenan was good law, and we would argue here that it still should remain good law.
But see, you have yet to make a single argument to us as to why it should remain good law. I mean, Keenan contained no state constitutional analysis at all, and its conclusion seems completely inconsistent with Elliott. So why? I mean, we may not get to that question in this case, but it seems to me that Keenan's days are numbered unless you can articulate an actual rational reason to retain a precedent that appears to have no foundation.
Justice Peterson, I agree Keenan has its problems. I would not represent to the court that it's perfect precedent. And I think that any part of Keenan that's retained would have to be specifically narrow. And the issue that we're asking that we narrow the issue on is not the Fifth Amendment analysis or even the statutory right of self-incrimination or even the conclusory language that it doesn't violate Georgia Constitution and presumably paragraph 16, but that it's cited to Turrentine versus the state. And I only bring up the difference between the tests in that there may be argument that this type of test by its nature is not incriminating. And if it's incriminating,
it's obviously incriminating because the state would not put it into evidence if it weren't incriminating. And you wouldn't put into evidence the refusal to take it if it weren't incriminating, and you wouldn't argue it. The argument you make in your brief is that there is some differentiation for paragraph 16 between things that happen before and after arrest. And that does not seem at all supported by the paragraph 16 case law going back to the start. Do you have a case that a case of this court that distinguishes paragraph 16 based on pre-arrest and post-arrest 4 stacks?
No, Justice Namias, and I would have to concede that point. I think that there's plenty of precedent. And I think, Justice Peterson, you cited to it in Elliott versus the state, the Aldrich case, it applied roadside. So I don't believe that there is necessarily a basis for preclusion with respect to the pre-arrest, post-arrest distinction.
So if paragraph 16 applies pre-arrest, what's your argument that Keenan is right?
The argument, and I understand Justice Namias asked, questioned whether or not it was not of an incriminating nature. But we believe that because this is not the type of test that would be admissible for a blood alcohol content, it's
not. You don't use it for blood alcohol content. You use it to prove the defendant was drinking alcohol, which is a very important part of a less safe case, right?
I would agree with you, Justice Namias, but I would also contend that alcohol, the presence of alcohol in of itself without any other evidence is not evidence of a crime.
Incriminating evidence. Is the state's position that incriminating evidence, that the definition of incriminating evidence is only evidence that all by itself convicts a defendant of a crime?
I think that in part, yes. And here's why I say that, Your Honor.
Cite me a case for that.
Well, Your Honor, I can't cite a case for that specific position, but the case that comes at mind that I'm referencing is State versus Orr. And the reason why I say that, and I do recognize that that was not evaluating a constitutional challenge as we are.
But even State versus Orr talks about evidence. Well, let me just put it this way. If it is not incriminating evidence, then it is not useful evidence for the state in a DUI case, right?
Well, no, Your Honor. And I think that if we read broadly, particularly that anything, because it's really a link, it's a step in painting an overall picture.
Okay, just to be clear, is the state's position that this does not help the state make its case? Because if that's true, we could just hold that it's not relevant evidence.
I don't think that it's not helpful in examining in making its case. I don't think that in of itself it's incriminating. And I would analogize it to not commenting on pretrial silence because in Orr, this court ruled that the rules of evidence, because there was no constitution preclusion, and certainly if this court adopted that paragraph 16 wasn't a barrier, then the only remaining barrier would be statutory rules of evidence. And of course, the state would have to proffer, pursuant to 24-4-402, a relevant reason for introducing evidence. But I don't think that it is the intention to construe all acts that may or may not consequently come in at trial, that these would all be incriminating
the
acts.
Issue in Orr, does Orr have anything to do with compelled acts?
No, Your Honor, it does not.
It's not at all a
so
paragraph 16 issue.
If your argument was right that this refusal evidence isn't incriminating, then Elliott would have come out the other way, because the evidence at issue in Elliott was refusal evidence.
Justice Peterson, I don't believe so, because I believe Elliott, I believe I was about to say portable breath test. The intoxilizer test, I believe, is incriminating, because if you blow in that or you receive blood evidence that is above a legal limit, that in of itself, it's
but the evidence at issue in Elliott was refusing. The evidence, the inference a jury draws from a refusal to take a portable breath test is precisely the same inference that is drawn from refusing to submit to the intoxilizer. It's evidence. It's the inference that the defendant believed that had they blown, it would have indicated that they had been consuming alcohol.
I mean, your distinction seems to be the distinction between a test that shows presence of alcohol and a test that shows the amount of alcohol, and the refusal as to both of those being somehow different. It seems to me that the tests are produced the same way via a compulsory affirmative act by the defendant, blowing deep air lung breath into either the portable test or the intoxilizer. So where am I wrong on how those tests are different?
And Justice Boggs, I think that that's where the lack of record here, there is a brief discussion with respect to the body cam on this, but I think that that's where the issue is because—
But none of that has anything to do with whether a refusal is incriminating.
I would agree with you, Justice Peterson. I was referring specifically to the point about the affirmative act and the compulsion, because a portable breath test, there is no compulsion there.
Can you touch briefly?
Go ahead, Justice.
Can you touch briefly on your last argument that the public's interest in prosecuting DUIs outweighs the individual's right to be free from compelled self-incrimination? And can you explain for us why the public's right to prosecute murder doesn't outweigh the individual's right to compelled self-incrimination? Because that would seem to be a problem for your argument.
Absolutely, Justice Peterson. And I will say this, and let me please correct any view that is the appellee's position, because it is not. As the court aptly pointed out in Elliott, this isn't a strict scrutiny analysis. And certainly we're not arguing that the state's rights or
that is pages 18, 19, and 20 of your brief.
I think, Your Honor, what the state was attempting to do was recognize and outline the considerable interests that are recognized. I think that would be more relevant to the issue of stare decisis, which we only arrive at if this court is inclined to overrule Keenan. But those rights cannot be trumped by our interests, albeit legitimate and I think very important. And I think that that's why this case is so pivotal in DUI case law, because it is going to pose challenges down the road in prosecuting less safe cases. Presumably the next at bat would be field sobriety tests, but that doesn't carry the day for the state. And I certainly would not argue to the contrary with the court today. We do have a legitimate basis in protecting the public, but we also recognize and must respect the rights of each citizen. And I believe that this court can take a principled approach in looking at the distinction made by Keenan as it cited to Turrentine as a way to—
But you've already said that. The approach you say is principled seems to be that ALCA sensor tests are not enough to convict you of DUI per se. But this is a DUI less safe case. And in fact, an intoxilizer can't convict you of DUI less safe, can it?
No, Your Honor, you're correct.
So they are no different in a DUI less safe case like this. So tell me the principal difference between them for a DUI less safe case.
Well, I think one, for a DUI less safe case, the intoxilizer, whether or not you instruct jurors that you're not looking for a number, I think the lack of a specific blood alcohol number always—
Well, but this is refusal. This isn't the actual, even the test. This is all the jury's not going to be instructed at all about any of it. It's just going to be able to consider that the defendant failed to take a test that seems to be incriminating, so he must be guilty.
No, Your Honor, Justice Namis, I don't necessarily believe that. And I will say this, with respect to the ALCA sensor test, even if the state puts it forth, again, I recognize it is a link in the chain that the state is using in the overall picture. But even driving a vehicle with the presence of alcohol, unless you're under 18, 21, and you're not allowed to drink alcohol in of itself, is not sufficient to convict someone even in a less safe case. And in these cases where they're inherently circumstantial in nature, and based on the scheme of investigations that we've relied on, the portable breath test, the field sobriety test, and the state administered test, applying a very broad approach that simply just one single recognition of alcohol being in the system is overly broad. And we would just ask that this court retain Keenan for the limited purposes and use this case as opportunity to clarify any irreconcilable differences with Elliott.
All right. Thank you, Ms. Lewis. Ms. Mignon, you have a little bit of time remaining for rebuttal.
Thank you, Justice. As the courts have just heard, the state has conceded that the portable breath test involves an act. It involves the appellant to engage in a deep breath, lung act that the officers are testifying to at trial as a positive or a negative. Because Georgia constitutional rights are not trumped by statutory law nor the Fifth Amendment, we're respectfully requesting, on behalf of the appellant in this case, that this court overturn the ruling in Keenan, specifically since Keenan, 1, did not address the 16th Amendment, and 2, is founded upon case law and statutory law that has since been repealed and overturned. Thank you.
Thank you, counsel, and thank you for bringing this case to our attention, and we look forward to digging in a little deeper. All right, we'll wish you well, and we'll part ways with you now. Y'all be safe.